Good morning, everyone. Welcome. If you could give me a thumbs up or a message in the chat to let me know if you can hear me okay. I'm in the office here at DPI and making sure that this meeting room that I'm in is got okay audio. Thank you, Abby. Okay. Well, excuse me. Well, welcome everyone. I am Donna Murray. I serve as the Digital Accessibility Specialist here at DPI. This is a fairly new role. I started in this role in November. Before that, this role did not exist. So excited to say that DPI has made a commitment to digital accessibility and putting some resources towards this work. So today we're going to do a deep dive into the ADA Title II rule. If you are able to join us at the 10 o'clock session, I'm following this one with a session about how to get started with a digital content inventory. But for the next 45 minutes, our focus will be on the rule. So this description was the webinar description that I put with registration. Explore the specifics of the ADA Title II and its implications for ensuring accessible digital content in K-12 PSUs and state government. So before we begin, just a few housekeeping things. Please stay muted when you're not talking, excuse me. Feel free to raise your hand, use chat, unmute. We have a pretty small group this morning. We had about 30 registered, so we might have a few more joining the call shortly. But it's a pretty intimate group, so feel free to interrupt use the chat or just unmute at any time. This is definitely a informal presentation in terms of participation, whatever works best for you. I'd like to try to answer as many questions as I can for you today. And certainly I'm available to meet one-on-one or reach out via email if that's easiest. There is captioning available in WebEx, so feel free to turn that on if that's helpful to you. Let me jump back here. The slide deck shortcut link is right here on the home page, or on the home slide, but I'll also put the direct link into the chat. So if you'd like to follow along individually, feel free to do that. I've also, you'll notice, have a link on this particular slide where you can make a copy of the slides. So if that's helpful to use to take notes, feel free to do that. And what's mine is yours. So if you'd like to make a copy and repurpose this presentation to deliver back in your PSU, feel free to do so. The recording and the transcript will be posted. I am recording all of the webinars. I just need some time to review that transcript and make edits and get that posted. So it should be posted within the next week or so. So I just put this slide in here just to make sure we're all on the same page about the content of today's session. So the rule itself that we're diving into today is actually 320 pages long, and I have read it multiple times. But certainly should not. The conversation today should not be misconstrued as legal advice. This is based on my interpretation of the rule and all the information and research that I have done around the rule. So let's jump in, and to kind of get us started, I'm going to talk a little bit about the ADA Title II and then talk about what the rule has to do with all of this. So the Americans with Disabilities Act actually became a law in 1990. Excuse me. So it's not new. And even though it doesn't use the word digital in the rule itself, in the rule language, it has been clarified by the Department of Justice since 1996 that it does include digital resources. So even though there's a new rule that specifically talks about a standard for meeting accessibility, I think it's interesting to note that the law itself has meant it to include digital resources since 1996. Title II does apply to state and local governments, and that's regardless of whether or not they receive that federal financial funding. And ADA is really just an extension of the Rehab Act of 1973. So we're familiar with Section 504. We talk about 504 plans and education, and that was intended to end discrimination against people with disabilities, but ADA has kind of expanded on that. So the Title II of ADA, again, is specific to state and local governments. And the language is that you have to make sure that your services, programs, and activities are accessible. So when I back up and talk again about the Department of Justice clarified in 1996 that it includes digital resources, that kind of makes sense when you think about the number of services, programs, and activities that we either provide through digital or we at least make people aware of our services, programs, and activities through digital content. Public facing, I'd say we put a lot of our content on a web page or some sort of mobile application for people to be able to access. So it does include that. Title II of ADA does include that. And again, it includes services offered online and through mobile apps. So the reason that the rule has come about now is that ADA has never specifically said, here's how you ensure that your digital content is accessible. There's not been a set standard, there's not been a technical standard, and the rule has changed that. So the rule applies to web content and mobile applications. It, again, establishes specific requirements and this technical standard that we're going to talk about today, and it's really providing clarity. So we've had ADA language since 1990, since 1996. It's been clarified to include digital, but we still have a wide landscape of inaccessible content, digital content. So the intent with the rule is to establish a technical standard and to help provide clarity about compliance. So the same people who have to follow ADA Title II are the same people who have to follow this rule. So it does include, for example, DPI, all other state government agencies, and local governments, which would include our PSUs. It also includes our public universities and our community colleges. It also includes when we contract with entities. So if we are, procuring a digital solution, then that's going to be used publicly, then it includes that as well. So our contracted entities, and we'll talk a little bit more about that when we look at some of the exceptions. So I just copied and pasted directly from the rule, excuse me, the web content definition. But I say it means all the things. I think the web content definition is probably exactly what you think it is. And the examples that are listed here, again, kind of encompass all the things. So text, images, sound, videos, controls, animations, and even our electronic documents. Now, the timeline for compliance is going to be based on not enrollment data for our PSUs, but on census data, so our population data from 2020. So I actually have linked here a spreadsheet where I looked at the census data for all of our counties and cities, and based on that population data, I have put in what your years to compliance start is. So it's either going to be 2 or 3 years. And if your population is greater than 50,000, then you have less time than our cities and counties who have less than 50,000. So greater than 50,000, you have 2 years from the effective date of the rule. And so the compliance start date is April 24th of 26. And I say compliance start dates because it's important to note that this will be ongoing work. Think about how often we change digital content, how often we procure new resources. So it's important to note that the compliance date is really the start date. If the population is less than 50,000, then you have 3 years. And the Department of Justice has clarified that by saying The assumption is that our cities and counties who have smaller population probably have more limited resources to devote to this work. So again, I have the link here for you to take a look and see when your compliance start date is. I've highlighted in this yellow here any of our city school districts because that was based on city population instead of county. And if you are a charter school, then think about the service area that you serve. So if you serve 3 or 4 different counties, then you need to look at those 3 or 4 counties on here and see what is the shortest compliance timeline. Is it 2 years or 3 years? If the shortest one you serve is 2, then that's your compliance start date. So the technical standard that's been attached to this is the Web Content Accessibility Guidelines, or WCAG, version 2.1 level AA. So there's multiple versions. Excuse me. I apologize for my coughing. I've got a drink and mints nearby, but I'll try to mute if I have a coughing fit. So the Web Content Accessibility Guidelines, there's actually multiple versions. Currently, 2.2 is already out and 3.0 is already in draft. But the Department of Justice landed on 2.1 because it's already been around for a few years. And there are 3 levels, A, AA, and AAA. And each one includes some more stringent standards. And so level AA is kind of right in the middle. Again, this does include, this technical standard will be required to be met even for times when we have an arrangement with someone who's making available web content on our behalf. So this does include, when we have procurements that include digital content, it's going to include any type of digital content that's posted on our behalf. So there are some exceptions to the rule, and this is really, we're going to spend most of our time talking about the rule today, is about the exceptions. Certainly, I think I am certainly of the mindset that everything needs to be accessible, but we recognizing that there's limited resources and oftentimes a ton of digital content that already exists, the exceptions kind of help us prioritize the work. So it helps us decide what things have to be remediated, which things don't have to be remediated. And then as you'll see in a lot of the exceptions, a lot of it is with that timeline of compliance date. So before a compliance date, what has to be fixed? And then of course, after the compliance date, everything has to be accessible unless it meets a couple of the exceptions here. So let's jump into those. This is just the short list, and we're going to talk about each of these in depth. So these are the limited exceptions that have been covered in the rule. And again, we're going to talk, I'm not going to read this to you because we're going to talk about each one of these in greater depth in the following slides. Before we do that, though, it's important to note that the exceptions don't change what the ADA what the ADA law already states. And that is that you have to provide individuals with disabilities with really an equal opportunity. So they've got to have effective communication, reasonable modifications, and again, this equal opportunity to participate. And so even if you have something that meets an exception, you may still be required to provide accessible formats if someone needs them. So if Donna Murray comes to you and says, this document is not accessible, I need an accessible version, even if you can say, well, we didn't have to make that one compliant because it met an exception to the rule, that still doesn't mean that you're going to that you don't have to create an accessible version for Donna Murray. So the law, again, has been in place since 1990. It's just this new technical standard is helping provide some clarification. So let's talk about the first exception, archived web content. And I think this one and the following exception are going to be two that we can hang our hat on quite a bit when it comes to previously created content. So in this first exception, there are 4 parts to it. So I have kind of this slide and the next one because it was too much text to put on one slide. So for archived web content, the first thing that has to be met is that it has to be one of the things listed here. It either has to be web content that was created before the compliance date, or it has to reproduce paper documents or other physical media that was created for the compliance date. So the commonality here is we're talking about things before the compliance date. They were created before your, 2026 or 2027 deadline. And so an example that the Department of Justice gives in the rule is, let's say I find a box of, old VHS tapes or some old photographs or documents, and I either scan them in or transfer them to, a digital movie. If I do that and then post it on the webpage before the compliance date, before, like on our website before the compliance date, that would count as archived web content. Maybe I have an old web page from an event that happened a few years ago and it's got its own web page. That web content could be considered as being, created before the compliance date. And as we see on the next slide, if it meets the second, third, and fourth requirement, then it can be considered an exception and does not have to meet that 2.1 standard. So basically, the short of it is content that was created before the compliance date. Here are the other 3 pieces to that. It has to be content that is really just for reference, research, or record keeping. So again, that example of like a web page that has, maybe some text and some images, and it's from an event a few years ago. And basically it's just there in case we want to reference it later, or someone's using it for research, or it's just to keep records. Then of course that would make it qualify for the first and second piece. The third and fourth the third one is talking specifically about not updating that content. So you can't have something that meets part 1 and part 2, and then you updated it today with some new content. If that's the case, then it's no longer archivable, at least through the terms of the rule. The last piece to this is that it has to live in a labeled space for being archived. So it has to be, as it says here, a dedicated area or areas that are clearly identified as being archived. So the Department of Justice in the rule was responding to a public comment because someone said, why don't you, in the rule, in the final rule, say something about that all archived web content has to live on a separate web page? And the response from the Department of Justice is, well, we want it to be labeled as being archived, but we're not going to specify exactly what that has to look like on a web page or a website, because everyone's, site maps of their website look different. So we want to give some flexibility. So maybe you have multiple web pages that have an archived section, maybe at the bottom, so that you can kind of still organize your content in certain ways. Or maybe it's best that you have a single web page that has links to all your archived web content. So you can kind of have some flexibility in how you organize it, but the intent here is that it's labeled as archived so that people can recognize, there might be some accessibility issues with this content because it's labeled as archived. So that's exception 1. That's the one that has the most parameters. But that's, I think, one of the exceptions that we'll be able to use, with a lot of content we already have. Oftentimes it's just for historical purposes. And if so, and it meets these 4 parameters, then we can call it archived web content and it does not have to be remediated. Again, if you have questions at any time, please unmute, interrupt me, or put the messages in the chat, or raise your hand, whatever works best for you. Now, this next exception is actually, when I first read it, I thought, did we not just talk about that exception with the archived web content? Because it sounds very similar. But the Department of Justice is basically trying to help again, help us prioritize what content that we're remediating and what content, kind of prioritizing our list, our order of priorities. And this exception kind of helps with that. So the exception here is about specifically electronic documents. And they're very specific in their description of electronic documents. It has to be either a PDF or a word processor, presentation, or spreadsheet file. And honestly, those are probably the most common electronic documents that you have created already. And again, this exception only applies if it was something that was made available before the compliance date. It can't be content that's that's currently being used. If someone needs to be able to access that PDF, maybe you created it 4 years ago, but it's a map of, the locations for, maybe it's bus routes, and you have PDFs of your bus routes. If those PDFs are still being used today, then even though you made them years ago, it would not fall under this exception. So again, this is about older content. Now, the difference between this exception and the first exception is that if you have these electronic documents that meet these exception parameters, you don't have to put them in an archived space. So I'm going to show you an example if you're following along on my screen share here. I've actually bookmarked a couple examples to show you of what I think would qualify for this exception. So I'm on DPI's EC website, and you'll notice that for child count, all of these are Excel files. You'll notice that this historically goes back to 2017. So I have all of these Excel files that are for child count, and all of them are obviously prior to the compliance start date. Now, there might be an argument to be made that some of these most recent files might still be important to access a few years from now after the compliance start date. But let's just say that all of this content is really just for record keeping. It's just older content that was made available before the compliance date, and we're not going to really use them anymore. I don't have to move all of these files. So that's what this exception does. It says if you've got conventional electronic documents before the compliance start date, and it's not something that people have to have access to be able to currently have access to your services, programs, and activities, then that content can stay just as it is, where it is. So in this example, all of these Excel files, they don't have to be moved to an archived area. They can stay right here. So that's, the difference between, sorry, I've got too many tabs open here. That's the difference between this exception and the one previously. Now, the next exception is content posted by a third party. It's interesting to note the example that the Department of Justice gave for this exception. They gave an example where maybe an entity has like a Facebook page, and Donna Murray, citizen Donna Murray, comes to the Facebook page and leaves a comment on a post and includes an image with it and does not put like alternative text with that image. That would meet the exception. So the exception actually is pretty narrow when we talk about content posted by the third party. But it's got to be content that really is out of the control of the entity. So it can't be content based on, maybe you have a contract or a license with a third party or some other arrangement. The rule does not clarify what other arrangements mean, but I think along the same lines as contractual or licensing, maybe a memorandum of understanding, something like that. With a public entity, then the third party content does not, if you have that contract, license, or other agreement, then it would not meet this exception. So think about obviously any content that you post as a state or local government entity would not be included in the exception. If the content is posted by this third party and they're kind of posting like on your behalf, I think of the example like a YouTube channel. Maybe you've contracted with a third party to provide some, to create some video content for your YouTube channel. That content would not be included in the exception because essentially you're sharing that information on our behalf, on the behalf of the entity. Let's see, Julie, let's see. What about general links that you can provide on your website, not links to resources? Okay, yeah, and Julie, that content would not, so essentially the rule very specifically states that, if I put links like just to external resources, I'm not responsible for ensuring that those external resources are accessible. I think there's some nuance there. If you have some sort of agreement, maybe you don't have a contract or a license, but some sort of agreement or arrangement, then that might be different. But let's just say I had like a page of resources for, families or students to find out more information about some topic. Then I'm not held responsible for the content that's shared in those third-party links. Unless I have a contract with them in some way. So, if, even the tools themselves, so let's say maybe there's a platform where, you've got, citizens, family members, students have the, ability to be able to post on a message forum, and you're providing that message forum platform for them. That message platform would need to be accessible. And that makes sense because again, it's a space that is being used for people to be able to access your services, programs, and activities. So if you're providing a message for them, a message forum for them, then that forum needs to be accessible. So the third party exception is pretty narrow. Again, I think the exceptions we'll likely use the most are the archived content and the electronic document. The next one, I've been trying to think of an instance where we might in K-12 education be using this exception. The example that's given for this exception by the Department of Justice is like a city water company, and maybe the water company puts individualized documents for the water bill, and I, as Donna Murray citizen, could go into the portal and access my personal individualized city water bill. And the only way to access it would be to, have my own password so that I can only access mine and it's specifically for me. That is what this exception stands for. So it has to be those word processing, presentation, spreadsheet, or PDF files, and it has to be about a specific person, property, or account, and it needs to be password protected. So the only reason I can think of maybe why the Department of Justice put this exception into the rule is I'm making an assumption here, but maybe because there are some processes already built out for things like, for like individualized bills, like the example that they gave. And so because of the effort and resources that would be required to make new processes and potentially, change, holistically change, or dramatically change the processes that are already in place for some of our state and local government entities. I'm guessing that that's why they included this type of exception. Again, I can't think of how this might fit for K-12. Val, your point about the parent portal. The thing is, and I'm not familiar with the parent portal in Infinite Campus, so you may actually have more information than I do on this, but the documents have to be those electronic conventional electronic documents, file types. So like with the parent portal, if it's just web-based and it's not essentially giving them the information in PDF or spreadsheet presentation or word processing file, then that immediately would keep this exception from being applicable. So, you know, I think it's going to depend on the functionality of the parent portal. So the next exception is pretty clear cut. Basically, if you have a social media channel, we don't have to go back prior to the compliance date and make those social media posts compliant to the rule. And that makes sense because most of our social media posts are pretty time sensitive. So it doesn't, this rule doesn't apply. Or I can count, pre-existing social media posts as an exception. And again, that makes sense. Most of the stuff we post on social media is time sensitive or time related. You know, it's like current events. And so we don't have to go back and edit, remediate those social media posts. So the next exception or exceptions are already included in ADA, and that's fundamental alteration or undue burden. Now, it's interesting, again, this is already built into the Americans with Disabilities Act, but the rule talks a little bit more about fundamental alteration or undue burden and puts a few more requirements with it. So basically, fundamental alteration is really exactly what it sounds like. If it's, if we're, especially, I think about when we're procuring something, if it's going to fundamentally change the functionality of the solution we're trying to procure, then we could use the exception of fundamental alteration. And the example I give is in North Carolina, a reading assessment cannot have the read aloud option because in North Carolina, that's not allowed. So we can't have read aloud for a reading assessment. So if I'm searching for a solution for a reading assessment tool, and I pick something that would officially not be compliant with WCAG because it doesn't offer read aloud functionality, then I could claim fundamental alteration as an exception. Undue burden is, if there's like administrative resources that you just don't have in order to make content accessible, then you could claim undue burden. But I want to caution you for that, against that, because we can't just hang our hat and say, we're already stretched too thin to be able to remediate content. That's, in my opinion, based on the language of the rule, that's not going to count as an undue burden. So, there's not kind of a clear-cut line on what would qualify for these exceptions, but the burden of proof is going to be on the entity. And the language in the rule says that it has to include a written statement of reasons. So what I've been working on is some guiding questions to help you determine if something might qualify for this exception. And it does state that the decision has to be made by someone in charge. So whoever, likely either, a director or superintendent or someone who's their designee. So don't think about hanging your hat on fundamental alteration or undue burden without doing some due diligence to be able to, qualify that with some burden of proof. Now, there are a few other things within the rule that the rule calls mechanisms for compliance. So I just want to cover those. They're not exactly considered exceptions, but some other ways that you can meet compliance. So we've covered all the exceptions that were included in the rule. These are just some additional things that can be used, leveraged for compliance. Conforming alternate version. So let's say, for example, what I think of for something that might qualify for this would be excuse me, maybe I have a PDF of some content, but then I also have a Word document, and the PDF isn't accessible, but the Word document is accessible. You can have conforming alternate versions, but obviously it's got to, be really exactly the same content, so same information, same functionality, but you can only use this method of compliance when it's not possible to make the web content directly accessible. And in the language, it says due to technical or legal limitations. So I think, again, the parameters are going to be pretty small here on whether or not you can have like an inaccessible version and then an alternate version that is accessible. So to the best of our ability, unless there's technical or legal reasons that we can't make the original source content accessible, that's really the only time that we would be able to use this option for compliance. Another one is minimal impact on access. So it was interesting because I thought, who's going to qualify what minimal impact is for access? And some of the examples that are given are things like decorative images have not been marked as decorative in the alt text. That's probably going to have minimal impact on access because a decorative image, if it's not marked as decorative, is still not going to cause someone with a disability to be missing out on much. Because you didn't mark it as decorative, they may, not be able to recognize that that image was decorative, but at the end of the day, they're not missing anything because it is a decorative image. So the minimal impact on access is, again, a pretty narrow parameter. In fact, I pulled language directly from the rule to give you an idea of how stringent this potential exception or whatever we called it, mechanism for compliance, as the rule stated. Listen to some of this language. It says, minimal impact is something that would not affect the ability of individuals with disabilities to use the web content or app to access the same information, engage in the same interactions, conduct the same transactions, and participate in or benefit from the same services, programs, and activities as people without disabilities. And it continues, in a manner that provides substantially equivalent timeliness, privacy, independence, and ease of use. So if you were wondering what minimal impact on access might mean, and who's going to qualify that, I think this language right here tells us that it's quite narrow in terms of the scope for minimal impact. Basically, it has to be, still equivalent in such a way that someone with a disability is really not missing anything that's going to keep them from having equal access. Now, in some instances, because again, the WCAG 2.1 level AA is not the most stringent of standards. There's also AAA. Now there's level 2.2 already in existence. So if you meet the WCAG 2.1 level AA and people still can't access it, you've met your obligation for the rule. Now, at the same time, remember, ADA says, even before the rule came about, says you've got to make sure people have equal opportunity. But in terms of meeting the technical standard, you don't have to go beyond the technical standard that's included in the rule, which is 2.1 level AA. So that's kind of the bar, and you don't have to go beyond the bar. Now, the next one says, if you want to go above 2.1 level AA, go ahead. So basically it's saying, the bar is set at 2.1 AA, but you don't have to stop there. You can go beyond anything that, it ensures that they have, equal opportunity. This is letting you know to, feel free to continue to innovate and provide flexibility to access by being able to push beyond that standard. Okay, so now what? So we've got about 5 minutes left. We've done the deeper dive into the rule, but I want to share with you a few resources that might be helpful to you as you start thinking about, now what? How do we start meeting this rule? One of the things I don't know if I've actually articulated explicitly in our conversation today is the fact that this rule is going to have to be complied with for all of our instructional materials, unless, of course, it qualifies for one of the exceptions. So the scope of this work is enormous, honestly, because we're really talking about all digital content moving forward, with the start of our compliance start date, has to be accessible. Some of the, you saw most of the exceptions are things that are for content that already exists. So again, it's helping us prioritize. We may not have a lot that we have to remediate, but certainly moving forward, we've got a lot of capacity building that has to happen around understanding how to make content accessible. So a few things, excuse me, that I've done to help us get started here. I have actually created a PSU self-assessment. So it's pretty, excuse me. Sorry, had to grab a drink. It's pretty simplistic, but really just to kind of give PSUs an idea of where they are when it comes to awareness about the rule. Have you put a team together of who's kind of lead this work? Have you done any kind of inventory or audit? What does that look like? Who's going to be responsible for remediating and ensuring that we're creating accessible digital content? Excuse me. And then how are we going to keep this going? Because the compliance start date is just that. It's the start date. So I have this with, a few different columns where you can actually kind of track your progress over time. That was really just intended to help you advocate within your PSU for resources, but also to tell the story of growth over time. I also have a document here where I've tried to kind of parse out what a 2-year timeline might look for a PSU, or a 3-year timeline if you have one of our smaller counties or cities. So I've put a 3-year timeline correspondence here in parentheses, so you can kind of see like what phases. One is just like, let's become aware, kind of put together a team, and let's see what kind of content we've got. And then what? So I've got phase 2 and phase 3 and then phase 4. And then I've even broken that down by strategies for each phase with some guiding questions and even a place for some planning notes if that's helpful. So feel free to take this, remix it, do whatever works best for you, make a copy, and hopefully that's a resource that will be helpful. In the next session at 10 o'clock, we're going to talk more about these digital content audit templates or inventory templates that I created. So one of them is pretty short and simple. I've kind of walked you through the different parts of it right here, but essentially I have a spreadsheet where you can really start just making note of all of the content that you have. And then, deciding what your priority is going to be, where you are in the audit process. Honestly, right now, I would just focus on inventory. And then I've got some webinars that will be coming up where I'll talk about how would you go about an audit? How are we going to determine what accessibility issues are there and how do we fix them? But essentially, this is just kind of your getting started template to start capturing your inventory. This expanded template, in my next session, I'll talk more in depth about that, but basically, the short of it is I've kind of divvied up some different digital content types, and each tab is a little bit different in its structure. And there's a little bit more detailed options for you to help identify what your priorities are going to be. So I have both of those templates if they're helpful for you. I even have some potential language that you might want to include within your contracts. So if you've got some contracts that are coming up for renewal that are going to extend beyond your compliance start date, I would encourage you to start looking at some of the contract language to see if talk with your legal counsel and your PSU to see if it's language that you can include either within your solicitation documents, your RFPs, and or within your contracts. And then I've linked to the WCAG 2.1, so I encourage you to start taking a look at that and just start familiarizing yourself with some of the standards. These resources, there's an additional fact sheet about the rule. I have a new digital accessibility website up that has lots of links, including a whole section on the ADA rule. And if you're not familiar with, if you're ever on Twitter or X, this is actually content that's been created by a bot, but I love it because you see, let's see, 1, 2, 3, 4, looks like 4 just today, 4 Twitter posts, X posts, and most of them are just short nuggets to help you focus on an accessibility strategy. Like, when you can, avoid number-only date formats. Sighted users can be confused on whether the first number is the month or day. So basically, it's just a quick tip for accessibility. So I think that might be helpful to you, and I think also something that you can share with others. All right, so we're about a minute over. I apologize for running a little over. If you're interested in joining a community of practice to learn alongside some of your colleagues, this will be an opportunity for us to talk about some problems of practice around accessibility and to support each other in the work. Feel free to fill out the registration form and then engage in whatever way works best for you. We have a webinar coming up at the end of the month. That'll be our launch for the community of practice. But if you can't make that, it'll be recorded. And then again, you can engage in whatever capacity you're able. And I tried to design this presentation with accessibility in mind. So I'm trying to model as well as help tell the story about what it takes to create accessible digital content. And again, what's mine is yours. Feel free to repurpose this presentation. And that's it for me. Thanks for joining us today. I'll stick around for a couple more minutes if there's any questions. And I am going to then jump over and get ready for the 10 o'clock webinar. If you'd like to join us for that, I will be spending the first few minutes digging into the rule just a little bit and talking about those first 2 exceptions because that will certainly play a part in how you start working on your inventory. So if you want to join at 10 and you want to join, maybe about 10 minutes late, that's certainly fine because the first 10 minutes so will be a little bit of a repeat of what we've talked about this morning. So thanks, y'all. Hope you have a great day.